Hi, I'm Kent Berk. I'm an attorney at the Scottsdale, Arizona law firm of Berk Law Group, where we handle trust, will, probate, estate, property, and other types of matters here in Arizona. So sometimes we get called and people are asking whether a will or a trust might be invalid based upon undue influence. So I'm going to explain in this video what is undue influence, what are the different elements for a court to evaluate in determining whether there was undue influence. So first of all, undue influence is where a person exerts such control and persuasion over the person's mind that the person who's adopting the will or the trust actually puts into the will or the trust not what they wanted, but what the influencer wanted. That's undue influence. So not all influence is undue influence. So if a husband and wife are talking about what they should put in their will or the trust, that's natural. That happens every day, and they may share ideas, or even a parent might ask their children, okay, I'm thinking about who I should designate as personal representative. Offering input on those issues is not necessarily undue influence unless the parent, for example, says they want to do something and the child says, no, don't do that. And the child is able to exert such control over their parent that the parent gives in and puts the child's wishes into the will or the trust, not the parent's own wishes. So whether there's undue influence is determined based on the totality of the circumstances, and the court will typically look at a variety of factors. First of all is whether the person was vulnerable to undue influence. Did they have dementia or memory problems, or were they dependent on their loved one for care such that they would logically be in a weakened mental position to give in to undue influence? Was the amendment to the will or the trust, or the will or the trust that's in evaluation, is it logical or reasonable in light of the circumstances, in light of the history of the person's estate plan? Was the questioned document inconsistent with prior estate planning? Did the person have a long-standing relationship with an attorney who drafted the estate plan, but all of a sudden the new estate plan, the will or the trust, was adopted by a brand new attorney? Was the influencer instrumental in getting the document, the new document, signed? Did they instigate signing of the new document? And there's other factors that are typically considered in determining whether the questioned document, the will or the trust, is invalid based on undue influence. Another issue that comes up in undue influence cases is what's called the presumption of undue influence. And for there to be a presumption of undue influence, there's three components, there are elements that must be satisfied. First of all, the influencer must be in a close personal relationship with the person who's adopting the will or the trust. The influencer must have been active in the procurement and execution, signing of the will or the trust, and then the influencer must be a primary beneficiary of the will or the trust. And if those three things are satisfied, then the burden will shift onto the influencer to show that they did not act with undue influence. If the presumption of undue influence does not arise, then the person attacking the validity of the will or the trust has the burden of establishing that undue influence renders the document invalid. If you have any questions regarding the validity of a will or a trust, whether it's based on undue influence, fraud, forgery, testamentary capacity, or any other questions, please don't hesitate to send us an email through our website or just give us a call. Thank you.